Could I ask you again the question that Justice Gorsuch asked, and to which you responded by citing the de facto officer doctrine? But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?
I'm not sure that anything gives military officers the authority to adjudicate effectively the legality of the presidency.
Why not? Because you say he's disqualified from the moment it happens. Now, I understand the de facto officer doctrine might be used to prohibit people from seeking judicial remedies for decisions that take place after the date he was disqualified. But if he's in fact disqualified from that moment, why would anybody have to obey a direction from him?
Well, ultimately, there still has to be some kind of procedure in place to adjudicate the disqualification. Certainly, Congress could impeach a sitting president, but that's the only remedy I'm aware of that exists for removal or otherwise negating the authority of a sitting president.
Why? Well, on what theory? Because the Section 3 speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless...
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside. He's disqualified from the moment, self-executing, done. And I would think that a person who would receive a direction from that person, the president, former president in your view, would be free to act as he or she wishes without regard to that individual.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is
no de facto. That doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside. Okay? I think Justice Alito is asking a very different question, a more pointed one, and more difficult one for you, I understand. But I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
I'm imagining a situation where, for example, a former president was a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
No, we're talking about Section 3. Please don't change the hypothetical, okay? Please don't change the hypothetical. I know I like doing it too, but please don't do it. Okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is, whichever party, that happens. Boom. It happened. What would compel... I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
Because ultimately we have statutes and rules requiring chains of command. The person is in the office, and even if they don't have the authority to hold the office, the only way to get someone out of the office of the presidency is impeachment. And so I think if you interpreted Section 3 in light of other provisions in the Constitution like impeachment, while they hold office, impeachment's the only way to validate that they don't have the ability to hold that office and should be removed.
Mr. Murray, can I just ask you about something Justice Kagan brought up earlier, which is the concern about uniformity and the lack thereof if states are permitted to enforce Section 3 in presidential elections. And I guess I didn't really understand your argument or your response to her about that.
Well, certainly if Congress is concerned about uniformity, they can provide for legislation and they can preempt state legislation.
Yes, but you say that's not necessary.
But it's not necessary. In the absence of federal enforcement legislation, these questions come up to this court in the same way that other federal questions come up to this court, which is that a state adjudicates them. If the state hasn't provided sufficient process to comport with due process, a notice, and opportunity to be heard, one can make those challenges. But assuming, as here, we have a full evidentiary record, an opportunity to present evidence.
No, I understand that we could resolve it so that we have a uniform ultimate ruling on it. I guess my question is why the framers would have designed a system that could result in interim disuniformity in this way, where we have elections pending and different states suddenly saying you're eligible, you're not, on the basis of this kind of thing.
Well, what they were concerned most about was ensuring that insurrectionists and rebels don't hold office. And so once one understands the sort of imperative that they had to ensure that oathbreakers wouldn't take office, it would be a little bit odd to say that states can't enforce it, that only the federal government can enforce it, and that Congress can essentially rip the heart out of Section 3 by a simple majority just by failing to pass enforcement legislation. Federalism creates redundancy. And here, the fact that states have the ability to enforce it as well, absent federal preemption, provides an additional layer of safeguards around what really Section 3
Yeah, and I'll ask you about the history when I get a chance again. Thank you.
Thank you, counsel. Justice Thomas? Justice Alito?
Suppose there's a country that proclaims again and again and again that the United States is its biggest enemy, and suppose that the President of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country. Could a state determine that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This Court has never interpreted the aid and comfort language, which also is present in the treason clause. But commentators have suggested, it's been rarely applied because treason prosecutions are so rare, but commentators have suggested that, first of all, that aid and comfort really only applies in the context of a declared war, or at least an adversarial relationship where there is, in fact, a war between two countries. And second, the intent standard would do a lot of work there, because under Section 3, whatever the underlying conduct is, engaging in insurrection or aid and comfort has to be done with the intent to further the unlawful purpose of the insurrection or to aid the enemies in their pursuit of war against the United States.
Now, let me come back to the question of what we would do if different states had adjudicated the question of whether former President Trump is an insurrectionist using a different record, different rulings on the admissibility of evidence, perhaps different standards of proof, then what would we do?
Ultimately, this Court would, first of all, if there were deficiencies in the record, the Court could either refuse to hear the case or it could decide on the basis of deficiencies of the record.
Well, would we have to decide what is the appropriate rule of evidence that should be applied in this case? Would we have to decide what is the appropriate standard of proof? Would we give any deference to these findings by state court judges, some of whom may be elected? Would we have to have our own trial?
No, Your Honor. This Court takes the evidentiary record as it's given, and here we have an evidentiary record that all the parties agree is sufficient for a decision in this case. And then, as I discussed earlier, there's a possibility of a Bose Corp independent review of the facts. But ultimately what we have here is an insurrection that was incited in plain sight.
But you're really not answering my question. It's not helpful if you don't do that. Suppose we have two different records, two different bodies of evidence, two different rulings on questions of admissibility, two different standards of proof, two different sets of fact findings by two different judges, or maybe multiple judges in multiple states. Then what do we do?
Well, first, this Court would set the legal standard, and then it would decide which view of the record was correct, I think, under that. If this Court had two cases,
which view of what record?
Which record? If this Court had two cases before it, and both of the records were sufficient insofar as both sides had the opportunity to present their case and the essential facts in the record that everyone agreed was sufficient for decision, then this Court would have to look at the evidence presented and decide which holding was correct, and then decide that issue for the country. And certainly here, when there is a complete record, lower courts then will be applying that decision, and I think it's unlikely that any court would say, we're going to reach a different decision than the U.S. Supreme Court did, particularly if the Court relies on the facts, the indisputable facts of what President Trump said on video and in his Twitter feed, which is really the essence of our case here.
Well, you had an expert. Let's just take that example. had an expert testify about the meaning of what President Trump said. But do you think it's possible that a different state court would apply Daubert differently and say that this person should not be allowed to express an expert opinion on that question? Do you think that's beyond the realm of imagination?
Not at all, Your Honor. 2 points on that. Number one, President Trump didn't appeal the admission of that evidence in this case. But number two, the second point is that Professor Simi really, he didn't opine on the meaning of President Trump's words. He opined on the effect that those words had on violent extremists. And the essence of his testimony was built around videotaped statements of President Trump himself encouraging, inciting, and praising political violence.
I'm not taking a position one way or the other about whether the expert's testimony should have been admitted or anything like that, or the meaning of President Trump's words. I'm just trying to get you to grapple with what some people have seen as the consequences of the argument that you're advancing, which is that there will be conflicts in decisions among the states, that different states will disqualify different candidates. But I'm not getting a whole lot of help from you about how this would not be an unmanageable situation.
If this Court writes an opinion affirming on the basis of the indisputable facts of what President Trump said on January 6th and in the weeks leading up to it, and his virtual confession on Twitter after the fact, then it would be reversible error for any other state to conclude otherwise on that question of federal law. Or at the very least, this Court could address that when those issues come up, but it seems unlikely.
Justice Sotomayor?
There's two sides to the other side's position. The first is that it's not self-executing. I want to put that aside. Deal with if we were to hold that states don't have the right to enforce or create a cause of action in this situation. They want the flip to say that no, but even Congress can't do it because they need implementing legislation. Address that argument. Because assume we rule that states don't have it, what would you have us say for the other side of the argument? One of my colleagues says you need, or not then Chief Justice, but Circuit Court Justice Chase said, which is that somehow you need implementing legislation, like the 1870 Act. You seem to say that's not true because they could decide not to seat a candidate, et cetera. So I don't know that legislation is necessary.
And certainly there are historical examples of members of Congress under Congress's Article I power to judge the qualifications of its members, of members of Congress refusing to seat ineligible candidates under Section 3 who have won election. In the context of the presidency, I think it would create a number of really difficult issues if the Court says there's no procedure for determining President Trump's eligibility until after the election. And then what happens when members of Congress on January 6th, when they count the electoral votes, say we're not going to count electoral votes cast for President Trump because he's disqualified under Section 3 under the Electoral Count Reform Act. A number of the amicus briefs, such as those of Professor Ginsburg, Hassan, and Foley, have made the point that that is kind of a disenfranchisement and constitutional crisis in the making, and is all the more reason to address those issues now in a judicial process on a full evidentiary record so that everybody can have certainty on those issues before they go to the polls.
Justice Kagan?
Mr. Murray, you relied on the state's extensive powers under the Electors Clause. You talked about the states having a role in enacting, typical ballot access provisions. I guess, it strikes me that we've put some limits on that, and I'll just give you Anderson versus Celebrezzi as an example of that, where we said, in fact, states are limited in who they can take off a ballot. And that was a case about minor party candidates. But the reason was that one state's decision to take a candidate off the ballot affects everybody else's rights. And we talked about the pervasive national interest in the selection of candidates for national office. We talked about how an individual state's decision would have an impact beyond its own borders. So if that goes for minor political party candidates, why doesn't it go a fortiori for the situation in this case?
Well, certainly constitutional principles like Section 3 apply to everybody, but in Calabresi, the issue there was a First Amendment question. And certainly there's no doubt that states' exercise of their power under Article 2 is constrained by First Amendment principles. And in that case, the state law deadlines for when a minor party candidate got on the ballot just came too soon to be reactive to what major parties had done and therefore risk disenfranchising people who were disillusioned with who the major parties had picked. And it raised First Amendment problems. Here there's no real First Amendment problem, and a state is just trying to enforce an existing qualification that's baked into our constitutional fabric.
Yeah, I guess, it did come up in the First Amendment, but there's a broader principle there, and it's a broader principle about who has power over certain things in our federal system. And, within our federal system, states have great power over many different areas, but that there's some broader principle about that there are certain national questions where states are not the repository of authority. And I took a lot, First Amendment, not First Amendment, a lot of Anderson's reasoning is really about that. Like, what's a state doing deciding who gets to who other citizens get to vote for president?
Colorado is not deciding who other states get to vote for president. It's deciding how to assign its own electors under its Article 2 power. And the Constitution grants them that broad power.
Well, but the effect of that is obvious, yes?
No, Your Honor, because different states can have different procedures. Some states may allow insurrectionists to be on the ballot. They may say, we're not looking past the papers. We're not going to look into federal constitutional questions. It's the sort of even in this election cycle, there are candidates who are on the ballot in some states, even though they're not natural-born citizens, and off the ballot in other states. And that's just a function of states' power to enforce, to preserve their own electors and avoid disenfranchisement of their own citizens.
Thank you.
Justice Gorsuch?
I haven't had a chance to talk about the officer point, and I just want to give you an opportunity to do that. Mr. Mitchell makes the argument that, particularly in the commissions clause, for example, all officers are to be commissioned by the president. Seems to be all-encompassing, that language. And I'm curious your response to that. And along the way, if you would, I poked a little bit at the difference between office and officer in the earlier discussion, you may recall. But I think one point your friends on the other side would make is, well, that's just how the Constitution uses those terms. So, for example, we know that the President pro tem of the Senate and the Speaker of the House are officers of the United States because the Constitution says they are. But we also know that they don't hold an office under the United States because of the incompatibility clause that says they can't. So maybe the Constitution to us today, to a lay reader, might look a little odd in distinguishing between office and officer. Not prepositions, nouns, but distinction. But maybe that's exactly how it works. Thoughts?
Well, I'd start with the idea that the meaning of officer in the 1780s was the same meaning that it has today, which is a person who holds an office. And certainly in particular contexts like the Commissions Clause, it appears that that's referring, that is referring to a narrower class of officers, because we know that there are...
Except it says all.
Well, we know that there are classes of officers, like the President pro tem, who don't get their commissions from the President.
Well, that's because the Constitution elsewhere says that.
We know that the Appointments Clause refers to a class of officers who get their appointment from the Constitution itself, rather than from presidential appointment. People who get their commissions from the President himself are not commissioned by the President. And so if you read the Appointments Clause in line with the Commissions Clause, then the Commissions Clause is really talking about the President's power. If one needs a commission, it's the President who grants it. But I think it's important to bring us back to Section 3 in particular, because that was 80 years...
Before we get to that, though, just the distinction between office and officer, do you agree that the Constitution does make that distinction, particularly with respect to the Speaker and President pro tem?